And now let's get started with the topic of the day. Today we're going to talk about enforcement and IP in Africa. This webinar is part of a cycle of 3 webinars because there's a lot to say, so we wanted to make sure that everyone will be able to also register to the topics that are more interesting for them. So we split the sessions into 3 cycles. The first one of today, it's on trademark protection enforcement in Africa, specifically for the ARIPO countries, the Africa Regional Intellectual Property Organization countries. The second one will take place at the end of November and will be on counterfeit goods and e-commerce in Nigeria and South Africa. And the third one will be in mid-December and will be focusing on custom recorders in West Africa. But let's start with today's webinar. I said that today's topic is trademark protection and enforcement in Africa. But before that, I would like to invite to speak my colleague Michal Kazimierek from the Observatory, who will be sharing with us some information on the risk of illicit trade in counterfeits. Let me introduce Michal before I give him the floor. Michal holds a PhD from the United Nations University in Maastricht. He started his career in public administration in Poland back in 2002, and he's been working at the European Union Intellectual Property Office since 2009. As a member of the chief economist team, he has been involved in several research projects focusing on IP contribution to the European economy, the impact of intellectual property on the performance of European companies, and joint project with the Organization for Economic Cooperation and Development on analysis of scale and trends of counterfeiting in the world trade. So without any further ado, I would like Michal to take the floor and to start his presentation. Thank you very much.
Good morning. So first of all, I would like to ask whether you can see my slides.
Yes, we can.
Yes, okay. So good morning again. And today I will present, so most of my slides that I will present today are based on the studies that we are doing together with OECD. We started this cooperation at the very beginning of the observatory 10 years ago. And the goal of this cooperation is to enhance the factual evidence on trade in counterfeit goods and illicit activities. So our joint reports, which will be more or less published twice a year, a report. So they are based on customs data, some qualitative interviews, and other data that we gather for specific reports. And we cover a range of very interesting topics focused on different aspects of counterfeit. However, I would like to start with setting the scene for this presentation. And this is the evolution of GDP per capita of the wealth in 3 countries of Western Europe. And as you can see, for many, many years, for hundreds of years, the economic growth and the economic wealth was stagnant and a very low level. And it started to growth in the 17th century. And what happened then? So the modern concept of intellectual property rights was developed in England in the 17th and 18th centuries. So a statute of monopolies in 1624, first statutory expression of patent law, where patents were granted for novel inventions, and statute of Anne from 1710, first copyright law. And there is a recognition in the economics of the importance of innovation and technology development for growth, because we have the finite resources, finite capital, finite labor that we can add to economy. So this is really very, very important to provide some incentives for innovation. And IP rights provide those incentives, and they helped Western Europe to start to grow and quickly develop. However, as you can see from this slide, the standard of IPR protection are not on the same level in all countries of the world. So on the left-hand side, on the wider axis, you can see the index of IPR protection. It's composite index of Property Rights Alliance, and it measures the copyright, trademark, patent protection, and also perception of IPR protection by the investors in those countries. And I highlighted in red the African countries. So you can see that as the GDP per capita grows, also the standard of IPR protection also grows. So this is not our idea. This is this slide or this plot is the idea of Keith Maskus, the US academic, and he had this idea that IPR protection follows this U shape. So countries, we cannot see it very well from this graph, but maybe for some countries. But the idea is that as countries are relatively poor, so they want to encourage the foreign direct investment, and they set the bar of IPR protection relatively high. However, as they develop the manufacturing capacities, they tend to lower the bar or the standards of IPR protection because they have the manufacturing capacity. They don't want to put the high standard to access the new technologies. They want to enable their firms to export and to copy the foreign technologies. And you can see from here that ARIPO countries, so we have the different situation, even among the countries which are situated on more or less the same level of economic development. We have Rwanda, which has quite a high standard of IPR protection. Eswatini, Zambia, Ghana, Botswana. However, we have also Zimbabwe, which has quite low standard, around 3 here. And here, this slide is directly driven from our reports, from reports we are doing with OECD. And we use the methodology developed by OECD to assess the scale of counterfeiting in international trade. So you can see that it's quite huge. So together with OECD, we estimated that in 2019, the value of the goods, counterfeit goods traded globally exceeds 400 billion euros for the entire world, and is close to 120 billion euros only for imports to the European Union, which is close to 6% of total EU imports. So back in 2017, we analyzed the routes of those counterfeit goods to the destination countries. And you can see here that it's mostly Asia, which dominates this trade. However, already some African countries are also put on this map, mostly as transit countries, but also producers of some counterfeit foodstuffs. And what I wanted to cover today directly is our recent report that we published at the beginning of this year, when we focused on the risks for SMEs stemming from counterfeit trade. So those are our sources of data. First of all, enforcement database from 3 different sources, from Digitaxud, this is the European Commission, US CBP, and WCO. So we have the information about the customs seizures of fake goods. It's a global scope, relatively long time span, since 2013. And we have the information about the brand infringed and the right holder. So based on this, we were able to tell whether the firm is probably SME or a large firm. And the second source of the data that we use for the study is our EU IPO SME scoreboard data. So we, since 2016, we published 3 such reports when we focused on the SMEs, and we surveyed around 10,000 companies those years. We asked them all sorts of questions related to IP, use of IP, the motivations behind the IP registration, but also about the infringement. And here we had the precise identification of SMEs, and we knew whether they use or not registered IP rights and what kind of IP rights they had. So first 2 slides will stem from those seizures data from customs officers that we gathered throughout the world. And as you can see here, that countries, the provenance countries. So the set of the provenance countries of counterfeit goods is dominated by China, Hong Kong, United Arab Emirates. So in comparison to the general report that we done for all types of companies, China and Hong Kong are more pronounced, more than in case of large companies, and Turkey and Singapore are less pronounced. And we can see also, although it's not really prominent place here, but we have also that Tanzania is among the countries that ranked relatively high as the provenance countries of the counterfeit. As we can see here, so you have like two bars. One bar is the number of seizures, so this gray bar, and the blue bar represents the share of the specific type of products in the value of the goods seized. And you can see that all kinds of goods can be subject of the counterfeiting, from the clothing through electrical machinery, perfumery, toys, and games to the pharmaceuticals. And pharmaceuticals are acute problem for Africa because it's a destination continent. Most of the African countries are the destination for the counterfeit pharmaceuticals, and it can create really, really very big problems, health problems. And the rest of my slides that I will present in these presentations are from the SME scoreboard. And as you can see here, and economists knew it very well from at least 80s, that IP rights register, formal IP rights play important role for the protection of the innovation of SMEs. But there is a whole range of formal and informal ways SMEs can protect their intellectual property rights, intellectual property, from internet domain confidentiality, trade names, also the speed of developing the product and put on the market. And the formal registered IP rights are relatively low in this scale. So this emphasizes that SMEs have to develop the really very complex, sophisticated strategy of IPR protection, where registered IP rights play important role, but also they have to think about other aspects, other ways of protection. And what was really strange for us, what was curious outcome of this SME survey that we conducted was that many firms, so 85% of the firms, use some means to detect infringement. However, majority of those firms use non-systematic gathering of information. So they rely on the customer feedback or incidental information, and they are not, they don't have the dedicated person, for example, to monitor infringements of their intellectual property rights. And then among the SMEs that have registered intellectual property rights, 15% told us that they have experienced an infringement of any type of intellectual property rights their own. And as you can see from this plot, the more innovative the company, the higher degree of the risk related to the infringement. So almost 20% of the firms that told us that they introduced the innovations which were novel to the world, they suffered from intellectual property right infringement. So you can see what are the consequences of those infringements. So over 40% of the firms that we introduced the innovations novel to the world, they told us that they suffered from the loss of turnover, loss of competitive edge, but also, and this is curious, so the many companies became more aware as a result of the infringement of the need of IPR protection for its products and activities. So it's better to be safe than sorry, and to to think about the IPR protection strategy before entering the new market outside of the European Union. So to think about it earlier. But also there were some firms in our SME scoreboard that told us that they refrained from IPR enforcement. So 11% of firms whose IPR has been infringed and they were aware of that didn't enforce their rights. And there was a whole range of the reasons that they provided. So, for example, too lengthy procedures, too high legal fees, or of court fees. So the last part of my presentation will be devoted to the econometric model that we ran. So we asked the question, what are the long-term consequences of the IPR infringement for SMEs? And we merged the SME scoreboard data and the Orbis database. Orbis database is the most comprehensive database of information about the various firms. It covers almost all the firms active all over the world. So we had the information about the survival, so the current status of those companies after 6 years after the first SME scoreboard that we did. And we checked what happened to those firms that told us back in 2015 that they suffered from IPR infringement. And also we had the control sample. We controlled for their size, age, innovativeness, sector, location, and dependence. So whether they were part of the bigger groups of firms. And this is the outcome. This is quite sophisticated econometric model. However, it implies that those firms, those SMEs that had IPR and they suffered from IPR infringement had 34% lower chances of survival over the 6 years than firms that owned IPR and they were not infringed. So to sum up my presentation, so IPR protection is crucial for economic development, yet in general, standards of IPR protection in developing countries are lower than in the EU. So it also brings some new risks, and it also warrants well-thought strategy of IPR protection before trying to establish the presence on those markets. Scale of international trade in counterfeits is large and affects all types of firms. So right IP protection strategy is crucial to mitigate those IP challenges when doing businesses outside of EU. And missteps in IPR protection may have dire consequences for SMEs, as we have seen from those econometric models that I just presented. So thank you very much for your attention.
Thank you very much, Michal. I think it was very interesting to hear this presentation because it helped us to put, let's say, into context what we are going to discuss now, knowing that, for example, that SMEs can have an impact on the turnover, but also on the survival of the company itself can be very important to take into consideration, referred to IPR infringements. So I don't see any questions from the audience unless someone wants to raise the hands or use the chat. Otherwise, I thank again Michal very much for your intervention, and I will now present the second and third speakers that will have a joint presentation. Today we're going to have Hora Otunam and Mario Schneider. We already collaborated with them in the past. They are specialized IP lawyers from IP Advocate Africa, which is based in the island of Mauritius. Nora is a lawyer focusing on anti-counterfeiting matters in Africa and specialized in enforcement of intellectual property rights. She previously worked in South Africa and the Gambia, and she holds a doctorate in law from the University of Pretoria in South Africa. And Marius, he's the founder and director of IP Advocate Africa, a law firm focusing again on the protection, management, and enforcement of IP rights all over Africa. He assists clients in setting up and enforcing their IP strategy across Africa, and he co-authored the publication Enforcement of Intellectual Property Rights in Africa, and serves also on the INTA Anti-Counterfeiting Committee, the UIPO Observatory, and the ECTA Anti-Counterfeiting Committee. So we have, it's really a pleasure for me to give them the floor and to share the presentation on trademark enforceability in ARIPO countries. So thank you very much. The floor is yours.
Thank you very much, Andrea. It's always a pleasure to cooperate with the EU IPO and the SME help desk. Yeah, so Michael, that was a very interesting presentation. I would like to sum up a few takeaways for Africa, specifically for Africa. We have seen that there are a few producer countries of counterfeits, mainly based in North Africa. Tunisia, we've seen Morocco, Egypt, also a few transit countries that are based in Africa. I've seen Egypt on the map and Nigeria. Nigeria is, of course, a very important economy because, as you all know, it's the #1 economy in Africa now. And you have raised the point and made the point, Michael, and thank you for that, that pharmaceutical counterfeiting is probably the most important problem in Africa because it does actually kill consumers, patients in Africa. 54% of all counterfeit goods found on the world are found actually in Africa. So that's the highest prevalence all over the world. And, you know, this is an important subject. And we have seen cases of counterfeit cancer therapy, counterfeit snake bite antidotes, so antivenoms, and, you know, really this causes consumers to die. So it is a very important subject. By the way, Nora and I have written an article on that just by way of introduction and to make the link now to from your excellent presentation to Africa. Now, we will be talking today about ARIPO, but I think ARIPO needs to be placed in the international, in the African context. So when you are, as a company, seeking to obtain trademark protection in Africa, you have to keep in mind a few fundamentals, which are the following. There are actually two regional systems for obtaining trademark registrations in Africa. There's, on the one hand, the OAPI, Organisation Africaine de la Propriété Intellectuelle. I'm going to go back in detail on this, but it's essentially West African countries, Francophone West African countries, and there is ARIPO, and this is the subject of our talk today. So there's two regional systems. I will explain them in a minute. Next to these two regional systems, there is, of course, also the possibility to use the Madrid system for the registration of international trademarks, which does allow right holders to designate a few African countries. Of course, not all African countries are part of the Madrid system, but some of them are. For example, OAPI is part of the Madrid system, and it is possible to designate the OAPI through an international trademark application. And in all those countries where that are not part of one of the regional systems or that cannot be designated by an international trademark filing, it is necessary to file national trademarks to obtain valid rights. That is the case, for example, for the top economies such as Nigeria, South Africa, DRC, Angola, just to name a few. And so in these countries, it is not possible to obtain registration through a regional system or through Madrid. You have to file nationally. So that so there is a coexistence of several different manners of obtaining trademark protection. Now, let's quickly have a look at OAPI. So OAPI is the acronym for African Organization for Intellectual Property, so Organisation Africaine de la Propriété Intellectuelle. The OAPI has been created through an international agreement, the Bangui Agreement, which has been adopted by member states as soon as March 1977. So it is a very long-standing system. It is much, much older than, for example, the community trademark. Yeah? So before the EU trademark, we had, the community trademark. So the ORP system, it's much older than the EU or community trademark. And it has just entered into force just after the Benelux, which is actually the first such regional system. So what is the Bangui Treaty? It is an international treaty that is directly applicable in each of the member states. The member states of OAPI are essentially West African, you can see them on the map here, West African Francophone countries. There is, I will not name them all because you can just read it on the map, but there is, of course, Senegal, Ivory Coast, the Guineas, Niger, Chad, Mali. These are countries that are part of the system, and also the Comoros. Astonishing because, we said West African countries. Well, the Comoros is an island in the channel of Mozambique. So they are also part of the system. Now, what in terms of trademark? Okay, so the OAPI extends to quite a lot of IP rights. So you can get a trademark there, you can get designs, patents, you can get all kinds of IP rights. We're not going to even name them all here. But in terms of trademarks, it's interesting to keep in mind that it's a unitary system and that by filing one single application, you can obtain the registration in 17 OAPI member countries. It's a unitary system, so one single trademark in all these countries. And the advantage is that use in one of the OAPI countries will keep your mark valid in all of the OAPI. Last point, contrary to the EU trademark, which is also a unitary system, which coexists with national trademark filings. So you can still designate, even if you have an EU, you can still file for a French or German national trademark for one reason or another. Well, this is no longer possible in OAPI. OAPI is the only territory that you can designate. It's one territory that you can designate. So that's for OAPI. And as I already said, the other system is ARIPO. Nora, you.
Yes, so hello everyone. It's lovely to be here with you. So now we're going to be talking a little bit about ARIPO, which is really the crux of our discussion today. So ARIPO regroups mostly Anglophone countries, very much for a long time focused on mostly, as you can see, East, Southern African countries, but it's really expanding to the West as well, and a little bit higher up to Sudan. So the aim of ARIPO has been from its beginning to have a common to bring together countries so that they could have a more harmonized system to pull together resources, to pull together financial and human resources. And at the same time, it has a very strong development focus. So the ARIPO was established in 1976 from the Lusaka Agreement. So today they have 22 member states, which you can see in yellow on the map. So what's interesting at ARIPO and very much differentiates it, if I may say, from OAPI, is that just because you're a member of ARIPO does not mean that you have the possibility to register IPR through ARIPO. That means that you can be a member of ARIPO, but you cannot be designated in, say, a trademark registration or a patent registration because you are not a member of a relevant protocol. I'm just going to take an example, for example, of Mauritius. Mauritius is a member of ARIPO. It's a relatively newcomer to ARIPO, but because it has not become a contracting state to the relevant protocol, you cannot designate Mauritius in a utility model, in a patent or a trademark application. So we'll learn more about the protocol in the next slide. Okay, so as you can see, as I mentioned, if you want to register specific rights, your contracting state needs to be part of a specific protocol. So for example, if you want to register patents and industrial designs and utility models, you have to go through the Harare protocol. You can only designate countries that are a member of a Harare protocol. Likewise, for traditional knowledge and expressions of folklore, you have a Swap Common protocol, and only member states that are contracting parties can be designated. And it is the same thing for marks. For marks, we need states to be parties need to be members of the Banjul protocol to be designated. It must also be mentioned that contracting states can choose which protocol they enter into. That means it's not like if you are part of the Banjul protocol for marks, you also have to be part of Harare protocol for patents and industrial designs. States are very much free to choose whichever protocol they are interested in being member of. And if they're not interested, they can be part of no protocol at all, or they can pick one or two or three protocols to be members to.
Okay. Oopsie, that was too fast. Hey,
Too fast.
back one. Hey, so we are talking about trademarks today here because we are, of course, with the EU IPO, and we've seen that companies are mainly relying on trademarks as registered rights in the presentation of Michael. Then we have to look at the Banjul protocol, as Nora just explained. The Banjul protocol, there's 13 countries that are actually part to the Banjul protocol, and that can be designated in an ARIPO trademark application. We're going to list them here. There's Botswana, Cabo Verde, the Kingdom of Eswatini, the Gambia, Lesotho, Liberia, Malawi, Mozambique, Namibia, Sao Tome and Principe, Tanzania, Uganda, and Zimbabwe. So it's interesting. So you can designate all of these countries in one ARIPO application, and it's a bit of a cherry-picking exercise because just as with the Madrid system, you can choose which country you want to designate. So it's different from the OAPI system, which we've seen before, where you can only get one unitary right in all of these countries. No, here with ARIPO and the Banjul protocol, you can select these different countries, and that's why we sometimes say it is an African mini Madrid system, actually. So that's where this comes from. Now, how does the filing procedure, how does this actually work and go about? Well, you can file your ARIPO trademark application either with the ARIPO office, which is in Harare in Zimbabwe, or you can contact in every of the member states. There is, of course, a national IP office, and you can also file your application through the national IP office, which will then, forward the application to the ARIPO office in Harare, Zimbabwe. Once you have filed your application and you have paid the taxes, so let me remind you, so you designate countries in which you want to have a protection, and you can also pick and choose the classes in which you want protection. This can be, again, à la carte. So you could say, okay, for example, for Uganda, I want to only one class, but you can say for Eswatini, I want 3 classes. So this is à la carte. So you designate the countries, you designate the classes, and according to this, the taxes will be calculated. By the way, the taxes are significantly lower than filing a national trademark application in all of these member states. So there is a significant saving that you can make by filing in several ARIPO countries. So you pay your taxes, and then the application is dealt with by the ARIPO central office. They will do a formal examination That is to say, is the file complete? Have you paid the appropriate taxes and the like? And once they are satisfied with this formal examination at the ARIPO office will send the application through for substantive examination to the member states' national offices, who will examine the trademarks under national law. So each of these member states are free to examine and apply their national law. And then once a trademark is accepted, it will be advertised in the ARIPO journal and published for opposition there. Third parties can then file an opposition if they do wish to do so. And the opposition procedure goes again under national law. So you have to oppose in all of these countries that are designated in a filing if you want to oppose. And it's every time a national procedure. So meaning that it is, if you want to oppose actually a ARIPO trademark application, it is actually quite costly because you will need to engage a lawyer in all of these ARIPO member states for your opposition procedure, which makes it more difficult and more complicated, and of course also more costly. And then at the end of the procedure, the opposition procedure, or if no opposition has been filed, well, the trademark registration certificate will be emitted by the ARIPO office.
Thank you, Marius. So I think that the reason, now we're going a bit too fast again. So the reason why most of us are here is we have a lot of queries regarding the enforcement of ARIPO trademarks. That's very honestly the biggest issue when clients are interested in the parties that are member to the Banjul Protocol. They want to register their trademark through ARIPO because many times it will be cheaper to register your trademark through ARIPO than designating nationally multiple countries. So clients are very much interested in an ARIPO trademark, but then always the same question, the same query, is my trademark going to be enforceable? Because of course, nobody wants to register a trademark if when something happens, when there's an infringement, you cannot enforce your trademark. So that's really the number one question that everyone has about ARIPO trademarks. So I think it's important really to restate ARIPO trademarks. So ARIPO trademarks, it's not a unitary right, but it's rather more like a bundle of trade. If you have an ARIPO trademark, it's rather more like a bundle of marks that you would have in various countries. So when we're going to look at the enforceability of the ARIPO trademark, I think it's important then to separate the issue among the different countries, because as you will see, in some countries, we're very sure of the enforceability, and in other countries, there are queries. So we can't just say ARIPO trademark, but really we need to look at the different countries that have been designated or that can be designated under the ARIPO trademark. So for example, there are countries for which we can say with a lot of certainty that the ARIPO trademark is enforceable. Those countries are Botswana, Malawi, Mozambique, Namibia, Sao Tome and Principe, and Zimbabwe. Why are we so sure? That's because the domestic laws have been amended to provide either explicitly for ARIPO trademarks, or they have been amended to provide for regional trademarks, of which ARIPO trademarks will be party to. So in those countries, if you designate those countries under an ARIPO trademark, there should honestly not be any issue regarding enforceability. It is clearly set out in the law. I'm just going to take the example of Malawi. Malawi has a schedule in its law regulating trademarks that is on the procedures applicable to ARIPO registrations. So then, of course, we can be quite sure that ARIPO trademarks would be enforceable because it is explicitly provided for in the law. So these are the easy countries. These are the countries where you have no issue at all. And then there are countries that we would label as probably likely. So as you can see, it's a yellow tick. We've kind of adopted the traffic light system. So, for example, there are countries where there is no explicit mention of ARIPO trademark under the law, but because of certain provisions, we believe it is very likely that the ARIPO trademarks would be held to be enforceable. So, for example, the first of those countries is Lesotho. If you look at the Industrial Property Order of Lesotho, it says that the provisions of any international treaty in respect of industrial property to which Lesotho is a party shall apply to the matters dealt with by the order, and in case of conflict with the provisions of this order, the provisions of the international treaties shall prevail. So it seems in Lesotho, the international treaty, the provisions of the international treaty as relating to industrial property will prevail over any conflicting provisions. So we can from this see that ARIPO trademarks are going to be enforceable. And if there's any issue with regard to the domestic law, the treaty, the protocol to which the states are party will likely then take precedence over any conflicting situation. Another country which would like to mention is Liberia. Liberia, again, we have classed it as a maybe country because so in Liberia, the Act, the Industrial Property Act, mentions ARIPO rights and grant ARIPO marks the same effect as mark registered domestically. So that's a very clear section of the law. So you might be wondering why we're putting it in the yellow category. Well, that's because the Act was published in 2003, but it was never passed by Parliament. However, the provisions of the Act are laid to by the Industrial Property Office with effect from the 1st January 2009, under an executive decision. So the law hasn't been passed, but an executive decision has said the IPO must obey the law in how it's dealing with trademarks, for example. So the Act is taken to be enforced in the country, although it has not been passed with Parliament. So we are of the opinion that it is likely that ARIPO trademarks designating Liberia will be taken to be valid because of an executive order, and also because if you do hold ARIPO trademarks to be invalid, that would also mean that you would have to hold national trademarks registered under the same law invalid, because then the whole executive, if you don't hold ARIPO trademarks to be valid, because you say the law hasn't been passed, it is only an executive decision, that means all of the trademarks would be in trouble because they're also being registered under the executive order, under the new law. So I believe that would put the whole system of the whole IP regime in disarray completely in Liberia. And for that reason, it is likely to be held by the courts that the marks are valid. So for the next slide, if you allow me to change my slide, the third and last country we put in as a maybe category is Uganda. So in Uganda, the law provides that an international agreement can only become part of a domestic law if it has expressly been enacted international law by an act of parliament. So there's really in Uganda this issue of domestication of an international treaty. If they become part of an international agreement, they also need to have an act of parliament that's going to make the treaty applicable in the national law. At the same time, there has been a case before the High Court of Uganda that's called Fabrics, Bolton Limited, the South African Queen, and that's a 2008 case, where the High Court did mention ARIPO trademarks and Uganda's designation under the ARIPO trademark. So the court didn't explicitly say ARIPO trademarks are valid, but the manner in which the courts mentioned ARIPO trademark and the agreement of a court that it was possible to designate ARIPO applications kind of inferred that the mark which designates Uganda for the purpose of registration is enforceable. And we can view this case as strongly in support of the argument that ARIPO trademarks designating Uganda are valid in Uganda. Sorry, here you go. This is full.
Yeah, sorry, I was on mute. I was on mute because I'm actually maybe that's also a word of explanation for all those who participate here. I'm actually on my agricultural project in Senegal, and there's a bit of noise around here. There's some birds flying around here, and yeah, so that's also my hair is a little bit in disorder because, as I say, I'm on holidays on my farm. Okay, so where are then the doubts when it comes to enforceability of ARIPO trademarks? The remaining countries are doubtful countries: Cape Verde, Eswatini, the Gambia, and Tanzania. They are doubtful countries. Why? Because they have this dualistic system where international treaties must be domesticated in order to be valid. They have not been domesticated, that is to say, incorporated in the national legal system, and hence there is doubt. And this doubt is very much in the mind of all our clients. Very often when we have clients that come to us to talk about ARIPO trademarks, they will say to us, this is an issue of enforceability. We don't really want these ARIPO trademarks because there is this uncertainty, this legal uncertainty. Well, I think to sum it up, what we can say is that this doubt, okay, there's reasons for this doubt, and it can be explained, the doubt, but de facto is highly unlikely that any of these ARIPO trademarks will be held unenforceable and invalid. Why? Because the ARIPO organization itself will be probably behind right holders who will want to enforce their rights, and also the national member states of ARIPO, they tend to, as we've seen in these cases, whenever it comes in front of national courts, well, the national member states tend to argue that they have signed an international agreement and that this agreement has to be given effect by the courts of law. So, and although there is doubt, one has to also say that we are not aware of one single case where an ARIPO trademark would have been held as being unenforceable by any of the national courts. So I think, there may be doubt, but, de facto in practice, the risk is not so big. Clients, and especially in case of SMEs, have to also consider budget. In terms of budget, an ARIPO trademark is certainly much less expensive than going through the national filings in all of these member countries. So there are some significant savings that can be made in terms of the taxes and, of course, also legal fees. So, that's, of course, I guess, the first consideration for an SME and even for larger multinational companies. The second point is you have to consider, the market. How important are these ARIPO markets for your company? And so maybe, let's say, if you are selling for $1 million every day products in one of these ARIPO countries, well, then you may well decide to also secure your rights through a national trademark in these countries. But it's actually a market issue and a business strategy. So you have to think about these points. So this, I think, concludes the let's say theoretical part of our presentation. And Andrea, except if there are already questions now, we can maybe continue to the practical part of the presentation, but maybe you want to allow questions, Andrea. I don't know how you wish to handle that.
Yes, maybe if we can go through some questions. Let's see if we receive any before we move to the practical one.
Case study.
Exactly. So, for example, if I lose an opposition in one country, does it mean that I lose my ARIPO trademark?
So you then, because it's a bundle of national rights, if you lose your opposition in one of the ARIPO countries, you only lose your rights in that given country. And, very often also it's going to be a matter of, product classes. So, you only lose that particular country. You don't lose it all. It's a good question, Andrea.
Thank you. For example, and do I pay by the number of countries that I designate?
Yes, you do. The more countries you designate, the more you shall pay. Although, as Marius has mentioned before, that will still remain much cheaper than if you had gone and filed as from two designated countries. You're very much likely to be cheaper than if you had gone the national filing route. Yes.
Mm-hmm. Yeah. And then, is it possible to apply to an ARIPO trademark online, or must be done at the office?
So, if I remember, ARIPO now allows e-filing. So it is possible to register a trademark to use the e-filing. However, if you're not an ordinary resident or you don't have your principal place of business in one of the Banjul protocol contracting parties, that is, not only are you a member of ARIPO, but you have contracted to the Banjul protocol, you will need an agent to file your trademark.
Okay, so that means that, for example, if I am from outside that country, I need someone who represents me in the country, even if I file it online. Is that correct?
So you will not be, so it will be e-filing by your agent then.
Mm-hmm. Yeah.
Like you will need to have an agent to do the filing. It's not going to be possible for you. For example, if I may, Mauritius, as I said, is a member of ARIPO, but not a member of the Banjul protocol. So even though we are technically members of ARIPO, we cannot file directly ARIPO trademarks, but we need to have an agent. So a Mauritian company cannot file directly an ARIPO trademark, but would need an agent in any other contracting state to the Banjul protocol to file a trademark and make use of the e-filing.
Yeah. And then another question.
And the same applies, of course, for an EU company. So let's say an EU SME cannot apply directly with an ARIPO for the trademark online, unfortunately.
Yes. Before we move to the case study, received another question that is the opposition filed directly in ARIPO that then notifies the designated country, or do we file in the designated country? And then another one, maybe you want to take this one first. You can see in the question and answers in the.
Yeah, so it's filed. I can't see the question and answer, but so the opposition is nationally filed. Huh? So it's filed not through the ARIPO office, but nationally through the national IP office of the designated member state.
Mm-hmm.
It's a little bit like in Madrid. Huh? So if it's similar like in Madrid.
Thank you, Marius. And is the publication done in ARIPO or in the designated country again?
The publication is done by ARIPO.
Uh-huh. And what deadline of publication prevails?
So the publication is done in ARIPO, but the opposition deadline is calculated according to national law. So that makes it a bit more complicated, but it's again similar to Madrid. So that's why we always call it an African mini Madrid.
Thank you. And then maybe one last before we move to the case study. Would you suggest to register via ARIPO system or Madrid system? Because there seems to be some gray areas in the enforceability of ARIPO trademarks.
That's precisely what we've discussed all along the seminar. There are some doubts on ARIPO, but we are not exactly certain that these doubts are more than theoretical and that they are actually justified in practice. But mind you that you can designate other countries through ARIPO than through Madrid. Through Madrid, you can only designate a very limited number of these African countries that are member to Madrid. You cannot designate all countries that are part of the Banjul protocol.
Yeah. Thank you very much, Marius and Nora. I don't see any other question coming up, so I kindly ask you to move to the case study, please.
So let's just move to the case study. Nora, I let you.
Yes, I'm sorry. I just.
Where is it?
It's coming back. I'm sorry, I'm moving my hands a bit around because it's summer here and insects.
Yeah, it is. So
I'm very
please go
sorry.
ahead, Nora.
So our case study is about a Belgian company. So of course we have a little bit anonymized the case study as you can imagine. It's just for the anonymity of our clients. But just to give you an idea of what had happened in Uganda. So we had a company that was involved in the manufacture of iron sheets. And had a specific trademark called Rolo. Of course, all of that is completely anonymized. So the company was very much involved across Europe. So it was a Belgian company, so it was very much focused on Europe. They had, however, done an ARIPO trademark a few years back for Uganda and Namibia because they had had a few discussions regarding licensing or maybe distributorship. I mean, there had been a few talks with other professionals in those two countries, and they had said, well, let's just register an ARIPO trademark at the time. The thing that happened is the projects didn't go through. The projects didn't go through. It didn't make it through, but they had already registered the ARIPO trademark, so they had it. So afterwards, the company came to us when they learned that in Uganda, there were some products that bore their trademark, the Rolo trademark, without the authorization. So it was the same type of products, that is iron sheets. And most likely that those products were being imported from Kenya, transiting through Kenya, coming from Kenya. They didn't know exactly from Kenya into Uganda. So they were being sold in Uganda. And they also learned at the same time that somebody had applied for the Rolo's trademark in Namibia, using the domestic, had filed a national trademark for Namibia. So I don't know, Marius, if I hop directly to what happened, to what they decided to do, and then we discuss a little bit the nitbits. What is that okay with you?
Go ahead, yes.
Yes. Okay, great. So what happened is, so of course, let's focus, if you allow, we'll focus on Uganda first, and then we'll focus on Namibia. Otherwise, we're going to get all mixed up. So in Uganda, the company, because we had the ARIPO trademark, and we also had the case
Maybe
law.
before that, sorry. Maybe before that, one thing that I think you need to keep in mind when you're looking at Africa are the routes of trades. So Uganda is a landlocked country. Uganda doesn't have access to the sea. So Belgian iron feeds, how would they arrive in Uganda? Unlikely they arrive in Uganda by plane. More likely they arrive through sea transport. And so that would mean that if they arrive by sea, then they can arrive in Uganda normally via Kenya. And that's actually what is said in your case, Nora. It comes through Kenya. Why? Because Kenya is the biggest port there. Mombasa is the biggest port in that Eastern African region. And this Mombasa port and Kenya does actually service a large hinterland, including Uganda, but also the eastern part of the DRC, Rwanda, Burundi, and the like. So all these countries are actually source their products through the seaport of Kenya. That is something to keep in mind, not only for Uganda, but for the rest of Africa as well. Because, for example, in Nigeria, the number one, we'll look at your question afterwards. Huh? I see there's a question. We'll look at it afterwards. So Nigeria, the number one economy, most of the products that go into Nigeria are imported through Benin and Togo, for example. So, you need to keep these things in mind when you're looking at enforcement strategies and how to tackle the counterfeit trade. Sorry to interrupt you, Nora. Go ahead.
No problem. So in this case, as I said, the company already had an ARIPO trademark that designated Uganda, and we were quite confident as to the enforceability of it before the courts because of that Anglo-American case that I mentioned earlier. And so what we already knew that we had different routes that were open to us. So we could maybe file for an injunction. We could maybe do a passing of action. We could maybe do a simple trademark injunction action. So we had both civil and criminal options that were open to us. So we were quite confident in that. But the first step that had to be done in Uganda was to do a market survey. So the market survey, of course, is to find out where are the goods, the volume. It also allowed the company to find the volume as well, the location, and also part of the reason the company was very willing to do the market survey is that they were hoping they would be able to find out who was importing those products, because they're not easy products to transport. I mean, they're not small products to transport. There's still a kind of a bit of an investment regarding those products. So we actually started off by a market survey. So the market survey, we actually found that the volume of counterfeit goods, the volumes of goods, sorry, not counterfeit, the volume of goods that were being sold were actually quite low. And we also found out that it was principally, mainly according to the inquiry, to the market survey and the investigators, that there was one company that was behind the importation of those goods in Uganda. Because the volume was quite low and it was only one person, our client decided not to go directly to the judicial route, but rather to write to the party that was importing those goods into Kenya, and kind of asking them for damages and asking them to stop bringing in those goods. There were a lot of discussions that ensued between our company, our client, and the guy that's importing. But I can say, was that finally there was a settlement that was reached. The matter didn't go to court, but a settlement was reached by the two parties. So that was for Uganda. We also had, sorry, yes?
Yeah, maybe if I can add, so why did we go for a settlement actually? Because number one, there was let's say, big uncertainty concerning use. As Nora pointed out in the expose of the case, our client had filed these trademarks because they had negotiations going on for possible licensing or distributorship with companies in Uganda and Namibia, but these projects fell through. So there was no actual use of the Rollo trademark in Uganda and the rest of Africa. Actually, in Uganda, there is a requirement that a registered trademark is put to genuine use 3 years after its registration. So 3 years and 1 month after its registration. So, there is a big uncertainty because, of course, once you initiate proceedings against a counterfeiter, it's very, very easy for the counterfeiter or the alleged counterfeiter, if I have to say it like this, the alleged counterfeiter to claim non-use of the trademark. So the first defense of every person accused of counterfeiting is, your trademark is not valid for one or the other reason, and non-use is, of course, a very good argument. So there was this issue of use or non-use rather, and the second point is that and it goes a little bit together with non-use. There was somebody on the market who was willing to sell iron sheets of a counterfeit brand, but so there was already somebody on the market who had a distribution network, who had customers. And so actually we have, if I may say so, found this counterfeiter. Can't really say that the person was a counterfeiter because, it's never been a decision that there's been any IP infringement. But let's say we turned the alleged counterfeiter into our distributor. That is something that actually happens quite often, especially when, a trademark owner doesn't use the mark yet. Then it's always a good option because actually the person is already engaged on the market, has a distribution network, has clients, and so it's actually a win-win situation for both. So I think that's really important to keep that in mind. Actually, in the end, you must find, as a lawyer, you must find a win-win situation, or a situation where your client takes away some benefit, and as in this case, turning an alleged infringer into a distributor is clearly a win-win situation, because the man started to sell our Rollo products very successfully immediately on the market there. Thank you.
Thank you, Marius. And so regarding our the trademark application, just to finish on the trademark application in Namibia, so we were not very, if I may say, we're not very worried about it, if I may use the term worried, because we knew we had an ARIPO trademark already that designated Namibia. We knew that Namibian law is very clear about the applicability of the enforceability of our ARIPO trademark. And we knew that even if it wasn't refused, we would have very, very strong chances if we ever went into an opposition for our trademark. So that is something we had heard that they had applied for, but we knew that all the chances were on our side if it ever got any further away, if it had been accepted or had been registered. Yes. And I think that's it for our case study. I see there's a question. I don't know if you mind, Marius, if I answer the question. So I just about the opposition deadline. So the opposition deadline is, so as you know, just to clarify and make things very clear. So you have the trademarks that are accepted and that are published in the journal, the ARIPO journal. And then you have 3 months from the moment those trademarks have been published in the ARIPO journal as accepted to oppose those trademarks. So that is, you have 3 months from publication to oppose those trademarks. But the content of your opposition and the way the opposition is going to be determined, that will be national laws. Yes, so I hope that clarifies everything. And unless there's any other question, we're back to you, Andrea.
Thank you, Nora. Thank you, Marius. I don't see any other questions in the chat. So I believe this was all on your side, and thank you very much for the time you spent today and for sharing this information on ARIPO and trademark enforceability, and also the case study that we heard. I see, the question if there will be a recording. Yes, we are recording this webinar, and we will make a training module out of it that will be published on our website in the coming weeks. So if you would like to listen again, watch again the presentation, that will be online very soon. And then, as mentioned at the beginning, this is just the first webinar out of 3 on enforcement and intellectual property in Africa. The next one will be at the end of November, on the 27th of November, when we will cover the subject of counterfeit and e-commerce in Nigeria and South Africa. So we will publish again the registration link on our website very soon, and I invite you all participants to register and to join again for that one at the end of November. So thank you very much, speakers. Thank you very much, participants, for being with us today. And I look forward to seeing you again next time soon. Thank you.